Hi, my name is Lisa Cummings, and today I would like to share with you some typical client QDRO situations that I have encountered and how you can plan ahead to avoid these. Just as a reminder, our firm is Cummings and Cummings Law. You can read more about our firm at www.cummings.law. We are a full service law firm and we support businesses and individuals. And more specifically, I have encountered across my career working with very large companies as well as individuals, how to support them and their retirement programs, as well as specifically dividing retirement benefits in the event of a divorce. Now I'd like to share with you some common QDRO situations. When discussing qualified domestic relations orders or QDROs, prospective clients often learn best through real-world scenarios and the answers to common questions. Today, we'll be looking at some case studies that will illustrate how these qualified domestic relations orders work in practice. And then separately, I'll be following up with a video of frequently asked questions, which can help address uncertainties that many divorcing spouses face. Together, these can help you understand the process and show why professional guidance is critical in the event of a qualified domestic relations order. Today, in this particular video, we're going to cover common QDRO situations. And then, in a following video, we will cover frequently asked questions. So just as a refresher, what is a qualified domestic relations order? A qualified domestic relations order is a legal order which is used to define a retirement benefit in a divorce. The individual who owns the retirement plan account is referenced as the plan participant. That qualified domestic relations order will grant rights to the former spouse or the dependent, and then that person will be called an alternate payee in the qualified domestic relations order. A qualified domestic relations order is required to avoid early withdrawal penalties and potential tax issues. The qualified domestic relations order must be executed by the divorce court and must also be accepted by the retirement plan to take effect. So what are some client situations that are common relating to qualified domestic relations order? To my surprise, in my practice, I have encountered individuals who have forgotten about the qualified domestic relations order, or perhaps they did not understand the importance of actually receiving a qualified domestic relations order. These particular scenarios are not specific clients, but are situations that will summarize what some of my clients have encountered. So for instance, I had a client who had finalized her divorce decree 5 years earlier. The settlement in the divorce decree awarded half of her former husband's 401k, but no qualified domestic relations order was prepared at that time. By the time the individual sought help in preparing a qualified domestic relations order, the husband had already withdrawn a large portion of the account. Because no QDRO was in place, that individual unfortunately had no enforceable claim with the plan administrator. This particular example highlights the importance of preparing and filing a qualified domestic relations order at the time of the divorce and not years later. Contrast that with the next situation. This was another forgotten QDRO. And this client had finalized her divorce 20 years earlier. 20 years earlier. In that divorce decree 20 years ago, the settlement had awarded half of her former husband's 401k, but no QDRO was prepared at that time. When she sought help, her husband was ready to retire and thankfully had not yet withdrawn any portion of the 401k plan. Even years after the divorce, a QDRO can still be filed with the original divorce court as long as the spouse's 401k plan account has not been withdrawn. This case highlights the importance of preparing and filing the QDRO at the time of the divorce and not years later. Another client situation is the importance of securing survivor benefits. In another example, a former wife was entitled to a share of her husband's pension. Without a qualified domestic relations order specifying the survivor benefits, her payments would have ended upon his death. Fortunately, the QDRO had been drafted carefully, which secured the survivor's annuity. When the participant passed away, she continued receiving monthly income for life. This example underscores how QDROs can protect future financial stability. Another client situation is avoiding tax pitfalls. A client came to our office after learning that her friend had been taxed heavily on a retirement distribution received in a divorce. By structuring her QDRO properly, we arranged for our client to first, through the QDRO, receive her share of her ex-spouse's 401k account and then transfer that amount to an individual retirement account or IRA so that upon that transfer to the IRA, the transfer was tax sheltered until such time as the client wanted to start withdrawing money from the individual retirement account. This avoided current taxation and preserved the funds for her retirement. The lesson here is that QDROs can prevent unnecessary tax burdens when they are handled correctly. For more information, I invite you to visit our website at www.qdro.law or contact me through my email, lisa@cummings.law. Thank you for joining us and have a great day.